My name is Thomas A. Bushnell. I'm an attorney licensed to practice law in Idaho, Washington, and California. And today I'm going to talk to you about a basic will. Not a will that comes with a trust package called a pour-over will, but a standard will. If you refer to the handout that should come up on the screen here, you'll see everybody at point A in that timeline, everybody should have a will, a power of attorney upon disability, and a living will. A will disperses your assets upon your passing, but that's not the most important article in a will. By far and away, the most important article in a will is who will take care of your children if you pass away and your children are under the age of 18. If you have that in your will, then, and you and your spouse both pass away, then these people will raise your children for you. They will be the guardians of your children. If you do not have this, or maybe your children don't have this for their grandchildren, what happens most of the time is a fight erupts between the maternal and the paternal grandparents to see who's going to raise that child. And those fights last for years. They're protracted, they're nasty, they're ugly, and us lawyers make a lot of money on them. Don't let that happen to you. Don't let that happen to your children with your grandchildren. Make sure your kids, even if they don't own a house, make sure at least they have a will. To have capacity to sign a will, we have to have three things. Number one, in law school they taught us you need to know the nature of your bounty. What does that mean? You need to know what you own. You have enough mental capacity to know what you own. The second thing you need to know is who are the natural objects of your affection. What does that mean? Well, that's your kids, the natural objects of your affection, your relatives. And the third thing you need to know is that you're making a final distribution of all your assets upon your passing. To be valid, a will does need to make a distribution of everything you own upon your passing, and it also needs to be signed by you and witnessed by two other people. When you're dealing with a standard will, and you have probatable assets, it will subject your estate to the process of probate, which I've mentioned takes 9 months to a year and on the average costs $5,000 to $8,000. To avoid that, we do living trusts. Many lawyers will just do a will, a standard will, and put their name on every page. And then when mom and dad pass away, you, the child, will see the will and say, oh, Tom was mom and dad's lawyer. Mom and dad trusted Tom. Let's go see Tom for the probate. That was your first mistake, trusting a lawyer. And so then you come, and as the lawyer, we make way more money on a probate than we do on a simple will. So it's a way to guarantee us more business in the future by having people do probates instead of doing living wills and getting their estate in order to avoid the probate.